My father took me to court over Grandpa's 11 milliliters. Your Honor, she's just a waitress. He laughed. The courtroom joined in. I opened my folder. By the time the judge finished reading, nobody was laughing anymore. The courtroom laughed at me at 10:14 in the morning. I know the exact time because I'd been staring at the clock on the oak-paneled wall since I sat down, using it the way you use a fixed point on the horizon when you're about to be sick on a boat. Steady. Keep your eyes on something that doesn't move. The second hand ticked. The laughter swelled. And somewhere behind me, a woman in a pearl necklace actually covered her mouth, not from embarrassment, but from delight. The way you'd cover your mouth at a dinner party when someone tells a joke that's funnier than you expected. I was the joke. My father sat at the opposing table in a charcoal gray suit that probably cost more than my car. He still hadn't looked at me once. His lawyer, a man named Attorney Douglas Sterling, 22 years of estate litigation, a wall of degrees from Penn and Georgetown, shoes you could see your reflection in, clicked his remote, and a photograph bloomed on the projection screen. Me, behind a coffee counter, green apron, hair pulled back into a bun that had been fighting gravity since 6 in the morning, steam wand in hand, a paper cup extended toward a customer whose face had been blurred for legal reasons, which struck me even then as deeply ironic, because my face was unblurred, my humiliation was unblurred, and the entire point of the photograph was that I should be seen exactly as I was. Documented over 3 weeks, Sterling said smoothly, clicking to the next image. Same counter, same apron, different day. We argue that placing $11 million in the hands of someone in a low-wage service position creates substantial risk to the estate of the late Gerald Whitaker. He let it breathe. He was good at his job. I'll give him that. He knew how to let a room marinate. The judge, the Honorable Warren Harrison, peered at me over reading glasses that had the kind of weight that comes from being worn by the same face for 40 years. Managing a multi-million-dollar portfolio, he said, and his voice wasn't cruel. It was almost conversational, which was somehow worse. Is quite different from serving coffee, Ms. Whitaker. More laughter. Polite, restrained, the kind that thinks it's better than itself. My father adjusted his cufflink. He didn't come here to fight me. He came to watch me disappear. What he didn't know, what none of them knew, was what was inside my tote bag. I need to go back 18 months, to a Tuesday in November, because that's where this story actually starts, even if the courtroom is where it ends. My name is Emily Whitaker. I'm 28 years old. I have a bachelor's degree in economics from a state school I paid for entirely by myself, a 2017 Honda Civic with a cracked dashboard, and until 14 months ago, I worked the 6 to 2 shift at a coffee shop called Harbor Grounds, in a harbor town in Connecticut that gets beautiful in summer and forgotten by October. I am also, as it turns out, the sole beneficiary of my grandfather's $11.2 million estate. I'll explain. My grandfather, Gerald Whitaker, Grandpa Gerald to me, Mr. Whitaker to the world of finance he'd inhabited for 50 years, was not a warm man by nature. He was precise, deliberate, the kind of man who said what he meant and meant exactly what he said. No more and no less. He'd built Whitaker Investment Group from a 2-room office in 1974 into a firm managing over $400 million in client assets by the time he handed off the operational reins to my father in 2011. After that, officially, he retired. Unofficially, he kept showing up at Harbor Grounds every Tuesday and Thursday. I didn't know he was my grandfather the first time he walked in. I'm not being dramatic. I genuinely didn't recognize him. I'd met Gerald Whitaker exactly 4 times in my life, at family functions where he sat in a corner, looked vaguely disappointed in everyone, and left early. My father and he had a relationship that I would describe charitably as a cold business arrangement, and my father had always made clear that the Whitaker money and legacy was his domain, not mine. I was the daughter from the first marriage, the inconvenient one. Gerald was just an old man who ordered black coffee, sat in the back corner table, and wrote things on a yellow legal pad. The first time he spoke to me beyond the transaction was a rainy Thursday in late October. I'd just come back from a 10-minute break where I'd been reading a financial quarterly on my phone, a habit I'd developed in college and couldn't shake, even working a job that had nothing to do with finance. I'd been trying to understand why a mid-cap pharmaceutical company had been posting strange numbers in the amortization column for 3 quarters running. I was muttering about it, half to myself, as I came back behind the counter. "It's deferred revenue recognition," the old man in the corner said, without looking up from his legal pad. "They acquired a licensing deal and they're stretching the recognition window. It's legal. It's also masking a cash flow problem they'll have to address in Q4. I stared at him. He looked up. His eyes were gray and very still. "You were talking loud enough," he said, without apology. I pulled out my phone and looked at the numbers again. Then I pulled up the footnotes on the licensing section of the same report, something I'd skimmed past, and read it slowly. He was right. I looked up at him. "You work in finance?" "I used to." "What sector?" He almost smiled. "Sit down," he said. "You have," he checked his watch, "9 minutes left on your break." I sat down. That was the beginning. I want to be honest about something, because honesty is one of the few things I've always had in abundance. I did not know for 4 months that he was my grandfather. He introduced himself as Gerald. I knew his last name was Whitaker. He paid with a card, but Whitaker is not an uncommon name in Connecticut, and it never occurred to me. He looked nothing like my father, or at least nothing like the man I'd built up in my head when I thought about the Whitaker side of my family. What I knew was this. He came twice a week. He always had a yellow legal pad. He asked me questions about finance, investments, portfolio theory, and risk assessment, and he did not accept vague answers. When I was wrong, he told me precisely why. When I was right, he didn't celebrate it. He just moved to the next harder question, which I understood as its own kind of praise. What do you do when an asset looks stable but produces nothing for 4 quarters? He asked one Tuesday in December, while I wiped down the counter between customers. Depends on whether stable means genuinely flat or masking volatility, I said. Is it a bond, a REIT, or equity? Equity, small cap. Then stable with no yield is a red flag. Either management is holding cash for an acquisition that may never come, or there's a governance issue they're not disclosing. I'd flag it for review and look at the board composition. He wrote something on his legal pad. Not my answer. Something else. A note about me, I realized much later. You ever work in finance professionally? He asked, the same way someone asks if you ever played competitive sports, with the mild curiosity of a person who already suspects the answer. I tried, I said. Graduated in 2019, applied to 12 firms, got 3 interviews, 1 offer, entry-level analyst position at a boutique in Hartford. I paused. They rescinded it when the pandemic hit. And then, I gestured at the espresso machine. He nodded slowly. No pity, just acknowledgement. It was the middle of February when he told me who he was. He said it the same way he said everything, flatly, without ceremony, as though the information were a data point and not a small grenade. My name is Gerald Whitaker. I believe my son is your father. My hands went still on the milk pitcher. He looked at me with those gray eyes. I've been watching you think for 3 months. I wanted to know who you were before you knew who I was. That's, I started. Methodical, he said. Yes. What came after that is something I've thought about almost every day since he died. Gerald Whitaker was, by his own admission, a man who had made a great deal of money and a great number of mistakes, and he had long since stopped being able to distinguish between the two. His relationship with my father was one he'd built on expectation and inheritance and the assumption that blood alone was sufficient architecture for trust. It wasn't. He'd watched my father manage the firm for a decade and had quietly, systematically moved his personal assets into a separate structure because, and he said this to me directly, without softening it, your father is an intelligent man who has never once been wrong about anything in his own mind, and that's the most dangerous kind of portfolio manager alive. What he proposed in the spring of that year was a working relationship. He had incorporated a small private entity, Whitaker Capital Analytics, LLC, a 1-person firm technically, but a 2-person operation practically. He would funnel a selection of portfolios through it for independent review. I would analyze them, flag anomalies, write risk assessments. He would verify my work, push back when I was wrong, and sign off when I was right. This isn't charity, he said, on the day he slid a simple 2-page working agreement across the corner table toward me. I'm paying you because the work has value. If it stops having value, I'll stop paying you. He paid me $3,400 a month, deposited to an LLC account he helped me set up, and he did it for 26 consecutive months. I kept working at Harbor Grounds because I didn't trust the money yet, or rather, I trusted the work but not the permanence, and I had a lease and a car payment and the specific financial anxiety of someone who learned young that safety nets dissolve. Also, if I'm honest, I loved that job. I liked the morning light coming through the harbor-facing windows. I liked the regulars. I liked being good at something physical and immediate, where the results were a warm cup in someone's hands, where nothing was abstract. My father didn't know any of this. I know that now with certainty, because my father never asked me a single substantive question in my entire adult life, not once. Not what I was reading, not how I thought about money, not what I wanted to do with my degree. He had formed a complete picture of me when I was about 17, difficult, ungrateful, academically mediocre, headed nowhere impressive, and he had never once updated that picture, because updating it would have required him to look at me, and looking at me cost him something he wasn't willing to spend. Gerald died on a Thursday in March, 14 months before the courtroom. He died at home, quietly, of a heart condition he'd known about for 2 years and had told almost nobody. He was 79. His will left his entire estate, $11.2 million in personal assets, investment accounts, and the Whitaker Capital Analytics LLC itself, to me. My father called me the same day the will was filed. I need you to understand, he said, his voice at the careful temperature of controlled rage, that this is a clerical error. He wasn't well. I'm going to fix this. He was perfectly lucid, I said. He told me, don't, he said, clipping the word, just don't. He hung up. 6 weeks later, I received a notice of formal legal challenge to the inheritance through the probate court of Hartford County. The petition, filed by my father through the law offices of Sterling and Marsh LLP, argued 3 things: that Gerald Whitaker had exhibited signs of diminished capacity in the final year of his life, that his decision to bypass his son and primary heir was inconsistent with prior estate planning documents from 2018, and this is the part that I read 3 times before I believed it, that I was demonstrably unqualified to manage a multi-million-dollar estate, as evidenced by my continued employment in a low-wage service sector position. My continued employment, as evidence. I sat in my car in the Harbor Grounds parking lot and read the petition twice. The salt air came through the cracked window. My hands were completely steady, which surprised me. I thought about what Gerald had told me once, on a cold February morning, when I'd shown him a risk assessment I was proud of. Anger is loud, he said, reading it. Proof is patient. I want to talk about what I did in the 8 weeks between receiving that petition and walking into Judge Harrison's courtroom, because this is the part part that matters. I didn't cry. I'm not saying that to sound tough. I cried plenty, alone at 11 p.m., in the way you cry when something confirms a fear you've carried for years, but I didn't let it be the loudest thing. I called a lawyer. Her name was Margaret Osei, JD, a probate and estate attorney with 19 years of practice who operated out of a two-person firm in New Haven. I found her through a referral from the accountant who'd helped me set up my LLC. She was direct, a little stern, and had a way of reading documents by holding them very close to her face that reminded me of Gerald. He's going for diminished capacity and incompetence simultaneously, she told me in our first meeting, spreading the petition across her conference table. The capacity argument is weak. Your grandfather's medical records will show he was cognitively sharp until the final month, and his physician, Dr. Anand Kapoor, can testify to that. The incompetence angle is nastier because it's designed to embarrass you into settling. I'm not settling, I said. She looked at me over the document. Good. What followed was the most important 8 weeks of my professional life, compressed into evenings after shifts, weekends, and 3 vacation days I'd been saving since the previous year. Margaret subpoenaed Gerald's medical records from Dr. Anand Kapoor, his physician of 11 years, who confirmed in a formal affidavit that Gerald Whitaker had exhibited no signs of dementia, delusional ideation, or impaired judgment at any point in his final 2 years of life. Dr. Kapoor, who had known Gerald since 2012 and had documented every quarterly wellness visit, was prepared to testify in detail. I pulled together every document from Whitaker Capital Analytics, 26 months of portfolio review logs, each entry dated, each bearing my name in the reviewer column and Gerald's initials beside it in blue ink. I had emails, I had LLC formation documents, I had the business bank account statements showing the $3,400 monthly deposits. I had a December email in which Gerald forwarded a client's feedback on a risk assessment I'd written. Your analyst's work is excellent. Tell her she caught something my previous firm missed for 3 quarters. He'd never told me about that email. I found it in the LLC's shared inbox the week he died. Then there was the sealed document. Gerald had filed it separately, through a notarized deposit with the probate court, 14 months before his death. The condition of its release was specific and almost eerie in its precision. It was to be opened only if his testamentary decisions were formally challenged in a court of competency. He'd written it in preparation. He had known this would happen. Margaret reviewed it in her office, and when she looked up at me, her expression had changed. Not soft exactly, but altered. He was protecting you, she said. He was documenting, I said. He didn't do anything halfway. The day of the hearing was a Friday in October. I wore black trousers, a dark blazer, and my good flats. I carried a tote bag, the same canvas tote I brought to work every morning. Margaret had suggested I dress more formally. I thought about it, but I'd decided I wasn't going to perform a different version of myself for my father's comfort. I brought my green apron. I don't know entirely why at the time. It was folded at the bottom of the bag. I just needed it there. Sterling was already set up when we arrived. He had a projector. He had a junior associate. He had a leather portfolio that he opened and closed with the specific confidence of a man who has never doubted a single professional judgment. My father sat beside him in the charcoal suit. He looked at the bench. He looked at the projector. He looked at the table. He did not look at me. The hearing opened with Sterling's presentation. He was smooth. I'll say it again because it bears repeating. He built his case from the incompetence angle first. The photographs, the narrative of an educated but directionless young woman who had failed to launch professionally, who had been coasting in service work for 6 years, who had no verifiable professional history in financial management. He used the word concerned 11 times. He implied that Gerald had been isolated, that his informal meetings at a coffee shop were evidence of a man retreating from his professional life, that the relationship between us had been that of a lonely old man and an attentive barista. Attentive barista. That's a direct quote. He was building a story and it was working. I could feel it working. The judge's expression was careful and skeptical. The woman in pearls, she was seated in the gallery, a cousin of my father's, someone who had always treated the Whitaker estate as a family resource, had her chin lifted in anticipation. Sterling clicked to the photographs. Me behind the counter, me in the apron, me handing a cup across the bar. The room laughed. I stared at the clock. 10:14. The second hand moved. Sterling requested a freeze on all inheritance assets pending a full competency review. Judge Harrison looked at me, and I want to be honest. His expression in that moment was not cruel, but it was not kind. It was the expression of a man who had formed a preliminary opinion and was waiting to be told why it was wrong. Managing a multi-million-dollar portfolio is quite different from serving coffee, Ms. Whitaker. The room chuckled. I rose from my chair. The room didn't go quiet immediately. It went quiet in stages, the way a fire goes out. The edge of the laughter tapered first, then the center, and by the time I reached the bench, the only sound was my footsteps on the floor. I placed my folder in front of Judge Harrison. Your Honor, I said, and my voice was steady in a way I hadn't been certain it would be. I'd like to enter into evidence my professional history as a portfolio analyst. Sterling said, objection. What professional history? This is exactly the point of counsel, Judge Harrison said, without looking up from the folder he'd begun to open. Please. Sterling sat back. Margaret had organized the folder precisely. Gerald had taught me that organization is itself a form of argument, that a well-structured document conveys credibility before a single word is read. The portfolio review logs were first, chronological, dated, initialed. Behind them, the LLC formation documents. Behind those, bank statements. Behind those, 2 printed emails, including the one about the client feedback. And And then, on a separate page at the back, the sealed document. Judge Harrison got to the review logs first. He read. His eyes moved. He stopped, went back, read a section again. I stood there. I didn't look at my father. I didn't look at Sterling. I watched the judge read, the same way I'd watched Gerald read my assessments all those months at the corner table, waiting for the moment when understanding replaced skepticism. These are signed by Gerald Whitaker, Judge Harrison said, not to me specifically, just to the room. Each entry, Your Honor, Margaret said, his initials in his hand, alongside Ms. Whitaker's name in the reviewer column, across 26 months of documented work. Sterling stood. Your Honor, these documents haven't been— They were produced through discovery, Margaret said evenly. You had full access. Sterling sat. The junior associate was typing rapidly. Judge Harrison turned to the sealed document last. He read it slowly. Then he turned the page over. Then he turned it back and read it again. At the bottom of the formal legal language, which described the working relationship, the LLC, the documented performance, Gerald's reasoning for his testamentary decisions, there was a section in my grandfather's handwriting, not typed, not dictated, written in his precise angular script in blue ink, on the bottom third of the final page. My granddaughter has earned my confidence through work nobody in this family respected because they never bothered to notice it. She finds what numbers actually mean. She reads until she understands rather than until she is comfortable. This estate will be safer in her hands than in those of any person who believes that where someone works is more instructive than how someone thinks. I am placing this condition on this document deliberately. I expect it to be needed. The room was completely silent. The woman in pearls lowered her hand from her mouth. Judge Harrison set the document down. He looked at my father with an expression I can only describe as clinical displeasure. Mr. Whitaker, he said. My father opened his mouth. Let counsel handle this, the judge said. Counsel didn't move. Sterling was looking at his portfolio. His jaw was doing something careful and controlled. He was recalculating. I could see it, the way you see someone redo mental math when the total comes out wrong. He said slowly, Your Honor, we'd like to request a brief recess to— The gavel came down. Recess granted. I went to the vending machine in the hallway because I didn't know what else to do with my hands and I needed something to hold. I was looking at the buttons, B4, peanut butter crackers, 85 cents, when I heard heels on marble. My Aunt Eleanor, my father's younger sister, she'd been sitting in the second row. She stopped beside me. Her voice had gone to that specific frequency that means I made a mistake and I don't know how to say it. Emily, I looked at the machine. Did you know he was going to use the photographs of me working? She was quiet for exactly long enough. That's my answer, I said. She put her hand out, almost touched my arm, then didn't. He's your father. He is, I said. I fed $1 into the machine. That's what makes it so clear. I pressed B4. The crackers dropped. Eleanor stood there for another moment, then walked away toward the women's restroom, which was the direction that required walking away from me. I ate the crackers. They tasted like cardboard and felt necessary. When we returned, nobody laughed when I walked in. I noticed it before I sat down. The recalibration in the room, the specific stillness of people who have revised their understanding of a situation and are now uncertain about their own earlier response. The woman in pearls looked at the gallery wall. The junior associate looked at his laptop. My father looked at the table in front of him. Sterling made a careful argument about the need for further review, the complexity of the estate, the precedent for court-appointed oversight. He didn't mention the photographs again. Judge Harrison denied the freeze. He said, and I wrote this down verbatim in the car afterward because I needed it to be exact, that the petition appeared to conflate employment status with financial competence, that the documented professional relationship between the decedent and the beneficiary substantially undermined the incompetence argument, and that the decedent's medical records provided no evidentiary basis for a capacity challenge. He also said, before he closed the session, looking directly at me, your grandfather's confidence in you will not be treated as a clerical accident. My father's face went red. Not instantly, slowly, the way color spreads in a tissue when you set one corner in water. Outside the courthouse, the air had that specific October smell. Fallen leaves, car exhaust, the edge of something cold coming in over the harbor. I had my tote bag over one shoulder and the unopened second half of my evidence folder tucked under my arm. I was walking toward the parking garage when I heard him. Emily. I stopped. I didn't turn all the way around. Just enough. My father stood on the courthouse steps. His jacket was still buttoned. His posture was the posture of a man who has not yet fully processed that he lost, because the loss hasn't yet landed on him the way it has on everyone watching. You embarrassed me, he said. I almost laughed. The sound started somewhere in my chest, and then I thought about the sealed letter, my grandfather's handwriting. They never bothered to notice it, and I let the laugh go quiet before it arrived. No, I said. I answered you. Those are different things. He was quiet. His jaw moved. He was reaching for something, the right register of authority, the right pitch of paternal disappointment. Then he found what he was looking for, and I could see it arrive in his face. The last weapon. Your grandfather would not have wanted this, he said. I put my hand in my tote bag. I felt the apron, smooth and folded, cotton still carrying the faint smell of coffee grounds and steamed milk. I pulled it out, smoothed it once with my palm. My father looked at it. Something crossed his face that I couldn't fully name. It wasn't quite guilt. It wasn't quite grief, but it was something that required those two words as raw material. He chose me, I said. He did the work to know why. I put the apron back in the bag. I turned toward the parking garage, and then my phone buzzed. I looked at the screen. One name, David Reese. My My stomach went cold in a single instant, the way a room goes cold when a window you've left open finally admits the winter. David Reese was the auditor Gerald had hired 18 months ago to conduct an independent review of Whitaker Investment Group, my father's firm, before transferring his personal assets to a separate structure. He was a forensic financial auditor with CPA credentials and a specialty in estate and fiduciary disputes. I'd spoken to him twice briefly in the context of paperwork for the LLC. He didn't have my number. He shouldn't have my number. I stood in the parking garage entrance with October light coming through the concrete lattice and stared at his name on my screen. I answered, "Ms. Whitaker." His voice was careful, the kind of careful that is itself a form of information. "I apologize for the timing. I've been waiting for the outcome of this morning's hearing. How did you—" I started. "Margaret Osie's office. She authorized contact." A pause. "There's something I need to discuss with you. It concerns the Whitaker Investment Group audit your grandfather commissioned." I leaned against the concrete wall. Around me, the city moved. Cabs, footsteps, a bus somewhere on the street level. "The audit Gerald commissioned," I said slowly, "was completed, wasn't it? He told me it came back clean. The summary report he received came back clean," Reese said. "The full audit did not." The cold in my stomach moved upward. "He never saw the full audit," Reese continued, "because someone intercepted the supplementary findings before they were transmitted to him. I have the transmission logs. I have the email that was used to redirect the delivery. And I have—" a pause so short it barely registered. "3 years of undisclosed related party transactions that your father's firm executed using estate assets that he had fiduciary responsibility to protect." I closed my eyes. The October light came through the concrete lattice. My hand was very still on the phone. "How much?" I said. "Approximately $1.4 million, Reese said. "Over 31 months, routed through 2 shell entities." Another pause. "I've already been in contact with Connecticut's Securities and Business Investments Division. Given this morning's outcome, they're prepared to move forward." I stood there for a long time after the call ended, long enough for 3 cars to pull out of the garage, long enough for the light through the lattice to shift. My grandfather had known something was wrong. He hadn't known all of it, hadn't known the scope of it, but he'd known enough to protect me from it, to move his assets, to build the LLC, to write that sealed letter 14 months before he died, to do what he always did: document, verify, prepare. He'd given me a gift, not the money, though the money was real, and I wasn't naive about what it meant. He'd given me time. 2 years of learning how to think about numbers the way they actually were, not the way someone wanted you to see them. 2 years of sitting at a corner table with a yellow legal pad and 2 paper cups. 2 years of answering harder questions. He'd taught me to look until things said what they actually meant. I walked to my Honda Civic, 2017, cracked dashboard, coffee shop parking permit still in the rear window, and sat in the driver's seat without starting the engine. I thought about the courtroom, the laughter, the apron on the screen. I thought about Gerald, back corner table, 2 paper cups, not once ever embarrassed to be seen talking to a woman in a green apron. He had seen me before I had seen myself. 3 months later, my father resigned from Whitaker Investment Group under a settlement agreement that included full disgorgement of the $1, $4 million in identified related party transactions, a 5-year bar from serving as a fiduciary for any Connecticut investment entity, and the surrender of his Series 65 investment advisor registration. Attorney Sterling's motion was formally closed. Petitioner's costs were assessed against the petitioner. Dr. Anand Kapoor's affidavit was entered into the probate record in its entirety. David Reese testified before the Securities Division for 2 days. His forensic report ran to 64 pages. He is precise, methodical, and thorough. Gerald would have respected him. Whitaker Capital Analytics, LLC, is still operating. I run it now, full-time, from a small office I lease above a bookstore 2 blocks from harbor grounds. My desk faces the harbor. I have Gerald's yellow legal pad, the last one he used, in the top drawer. I haven't written on it. I don't think I will. I still go to harbor grounds sometimes. 6 to 2 shift crowd, Tuesday and Thursday regulars, the espresso machine with the temperamental steam wand. Maria, who trained me 7 years ago and makes the best cortado in the county, saves me a corner table when she knows I'm coming. Back corner, where the light is good. I bring a legal pad. Sometimes a client's quarterly report says something that only makes sense if you already know how to listen. Sometimes a number hides behind another number and waits for someone patient enough to find it. I look until I understand. Gerald taught me that.